I tried to keep this as brief as possible in the interest of having time to discuss. The last two webinars I've been on with all of you, I ran a little long. So I'll try to put all the good info out there, and then we can get down to talking through whatever questions or cases anybody wants to talk through. So today's topic is mandatory reporting requirements, and we're going to look at child abuse and neglect, elder abuse, and felony reporting. The duty to protect, duty to warn, we talked about specifically on a previous webinar. So these are the three I figured we would focus on today. So on this first slide, I wanted to give an idea not only of the code section where you can go to for additional information, but just a list of mandated reporters. So for child abuse and neglect, physicians, licensed psychologists, licensed social workers, counselors, and therapists. Elder abuse talks about certain physicians. It's kind of interesting. It says those engaged in, that have a license to practice certain types of medicine and surgery. I thought I had it here in front of me, but it limits when it talks about physicians, the types of physicians it covers. But then there's that catch-all category at the end that if you are a physician who is also an employee at a community mental health agency, a health department, an outpatient health facility, a hospital, a residential care facility, a nursing home, or home health agency, you would still be required to report. But just know when you look at the rule itself, it doesn't say all physicians. It has a weird kind of carve out. Licensed psychologists and licensed social workers, counselors, and therapists as well. And yeah, keep in mind that that last category is all employees of those types of organizations have the elder abuse mandatory reporting duty. And then for felony reporting, it is not limited by physician, any person. So, your next door neighbor who's not in any of these professions would have the same duty to report. There are no specific professions listed in the statute, and we'll talk about that here in a little bit. So, all right, diving into child abuse and neglect. So what the statute states is if you have knowledge or reasonable cause to suspect based on facts that you are aware of that would cause a reasonable person in a similar position to suspect. So keep in mind that knowledge is not required. There's also that reasonable person and reasonable cause standard, that a child under 18 or a person under 21 that has a developmental disability or impairment has suffered or faces a threat of suffering any physical or mental injury, disability, or condition of a nature that reasonably indicates abuse or neglect. If all those criteria are met, if the person is under 18 or under 21 with a disability or impairment, and you have direct knowledge or reasonable cause to suspect, based on facts that you're aware of, that a reasonable person would also suspect that they have suffered or faces that threat of suffering injury, and it reasonably indicates abuse or neglect, then there is a duty to report for those persons listed back here on this slide. There are other persons listed in these statutes. I pulled out the ones because some of them have like 40 different professions listed. I pulled out the ones that are healthcare related, but keep in mind that if you are one of those professionals and this criteria is met, the duty to report exists. And what the requirement for reporting is that you shall immediately report that knowledge or your reasonable cause to suspect to either a public children's services agency or law enforcement in the county in which the child either lives or where the abuse or neglect occurred or has occurred. And if the child is an inmate in a correctional facility or DYS or what have you, State Highway Patrol is who the report goes to. The report must be made by phone or in person. There is no emailing or through the website, and it shall be followed by a written report if requested. The written report must contain name and address of the child and parents or persons having custody, age, the injuries, that are known or reasonably suspected for the child to have, including any evidence of previous injuries, abuse, or neglect, and then any other information that might be helpful in establishing the cause of the injury or the abuse or neglect. And that includes reports of medical exams, tests, or procedures. I didn't go into detail here for the sake of time, but the rule actually specifically allows taking photographs, doing examinations, conducting tests to help substantiate or to document the suspected abuse or neglect. So those things are specifically, if taken, required to be included in the report. So in terms of privilege, this is kind of an odd little exception here. It says that a physician, there's no other exception for privileged communications for any other profession, but for a physician, they're not required to make a report if they couldn't testify with respect to a communication because of the physician-patient privilege, unless the patient is deemed to have waived the privilege, and they shall make the report if the person at the time of communication is under 18, under 21 with the developmental disability or impairment, the physician has that same knowledge or reasonable cause to suspect standard. And a third criteria of the abuse or neglect does not arise from the patient's attempt to have an abortion without parental guardian or parent or guardian notification. So a few things here. Essentially, other than that third criteria that I'll talk about here in a minute, it says you're not required to make the report if there's physician-patient privilege unless all of the same requirements of the rule apply. So I think there are 2 points for this carve-out that then essentially requires reporting ultimately in most, the vast majority of cases. I think where it says at time of communication here is key. It's making it clear that it's not about reports of past abuse or neglect. It's saying when it's communicated, the person is that age. So this isn't a 23-year-old talking about what happened in the past. And the other piece of it is that third criteria about an abortion. I'm pretty sure the rationale for this is the statute about obtaining an abortion without parental or guardian consent states that a minor can go ahead and obtain that abortion if they have, without consent, if they have alleged that abuse has occurred at the hands of their parents or guardian. So it would essentially counteract the intent of that law if it was reported under this law. So I think they're just trying to carve out in recognition of that other law that allows that abortion to proceed if there was abuse or neglect. It would counteract it if a physician then goes and reports that abuse or neglect. So we can talk about that more if there are questions. So for persons who do report under this law, they are granted immunity from civil and criminal liability, and that includes the reporting, providing information, participating in proceedings, and participating in conducting medical exams, tests, or procedures to document, unless the professional has went outside the standard of care that's applicable to their specific profession. The reporter, the mandated reporter, is also granted the authority to get information when they want to follow up. So you can contact, if you have provided as a mandated reporter your name, address, and phone number so they can verify it's you, you can call Public Children's Service Agency to find out if an investigation's been initiated and its status, if the agency has been involved with the child, the general status and condition of the child, and whether your report resulted in filing of a complaint in juvenile court or criminal charges in any other court. So you actually have a right as a mandated reporter to follow up and get that information. They're required to provide it to you. Failure to report is a misdemeanor of the 4th degree. And there's also, I think this is rather new, there's liability imposed for compensatory and exemplary damages to the child for failure to report. All right, elder abuse. Elder abuse, again, if you go back to that first slide, it is the one that has the specific physician category, licensed psychologists, licensed counselors and therapists, and then any employee of that laundry list of health-related facilities, including nursing homes and residential care facilities, home health care. So persons that are listed under the statute, if they have reasonable cause to believe that a person 60 years of age or older is being abused, neglected, or exploited, or in a condition which is a result of abuse, neglect, or exploited, they are required to make a report. And, again, it's that reasonable cause to believe. So looking back at child abuse, very similar. That's reasonable cause to suspect. This is reasonable cause to believe, essentially the same standard. If there is that reason to believe or actual knowledge, the requirement is that the mandated reporter must immediately make a report to the county JFS. It must be made orally or in writing. I believe each county on their county JFS on their website has the specifics of how a report can be made. The JFS must be available 24/7 to receive written or oral reports. So don't worry if it's after hours, middle of the night, a Sunday, they are required to be available for a written or oral report. And an oral report must be followed with a written report if so requested, and very similar to what we looked at under child abuse, certain things must be contained in that written report if it is requested. A couple other things I noted here. The report is not a public record, but it must be made available to the adult and their legal counsel unless there is a risk of harm to the mandated reporter or to the adult. Name and identifying information of the reporter can be redacted before giving the rest of the report to the adult and their legal counsel. Persons that, similar again to child abuse, persons that do report and subsequently testify are immune from civil or criminal liability unless there's some bad intent there, or they made the report maliciously, or if they perjure themselves on the stand. There is also whistleblower protection. As I stated, the categories of mandated reporters include any employee of that whole list of healthcare related facilities. So there is whistleblower protection. It says they can't be discharged, demoted, transferred, not a negative work performance evaluation. You can't reduce their benefits or pay or take any other action detrimental to them in any way to retaliate against them for making this report. And our third category is felony reporting. And the statute instead of saying any person must report, it says it kind of backwards here. So that's the awkwardness of this language. It says that no person, so there's no professional category specifically, this applies to anybody and everybody, no person knowing that a felony has been or is being committed shall knowingly fail to report that information to law enforcement. It goes on to say that disclosure of information under this requirement does not give rise to any liability or recrimination for breach of privilege or confidence, and there are misdemeanor penalties for failure to report. There is a privilege exception under this. So an exception to the reporting requirement is that if the information is privileged by reason of the relationship between physician and client, therapist and client, that whole laundry list there, and their client, or if the disclosure would amount to revealing information that was obtained while the person was receiving treatment or services in a substance use disorder program. So those are the exceptions to the felony reporting requirement if that privilege does indeed exist. So those are the 3 reporting requirements in a nutshell. Just some additional considerations for all these. Keep in mind the mandated reporters aren't required to investigate, and actually doing your own investigation could impede a later official investigation, so best not to. There's no proof required. You just have to state the basis of belief or knowledge that you have. You're required to report even if somebody else already told you they have. You have to fulfill your own personal duty under these laws and not just say, okay, it's already been reported, so I don't have to. The only exception to that is in the child abuse, neglect, and reporting statute. It specifically says that if 2 or more healthcare professionals are providing healthcare services to the same child and they determine or suspect and report accordingly, they can make a single report out of those two. One of those 2 professionals can make a single report, and it will have deemed to have been properly made by both of them. Keep in mind always err on the side of caution and report child and elder abuse or neglect. I mean, that's the intent of these statutes. You're not supposed to have definitive knowledge. It's a belief. It's suspected based on your professional determination. So if you're like, I think something's going on here, if you have that nagging suspicion, even err on the side of caution. And if there wasn't any child abuse or neglect or elder abuse or neglect, the authorities will make that determination, but err on the side of caution in protecting the child or adult. In terms of confidentiality, HIPAA permits disclosures that are required by state law. So confidentiality, meaning the disclosure of the information, isn't an issue. As I did mention, in some instances, privilege is an issue. And also professional licenses require compliance in Ohio with the mandatory reporting laws. So in addition to those other potential liabilities and criminal charges, all misdemeanor, I believe, there's also risk of putting your professional license in jeopardy if you don't comply with the mandatory reporting laws. So that was a lot in a short period of time.